So, Mr. Smith, is what your counsel has informed me correct, sir?
Yes, sir.
And that is your decision?
Yes, sir.
All right, very well. Will there be other evidence for the defense?
No, sir.
All right, very well. What I'll do then is bring the jurors in. I will ask you, in the presence of the jury, whether there is evidence for the defense. I'll allow you to answer that. And assuming the answer is no, then I will inform the jury that we're going to release them for the day and tell them that we'll begin Monday with closing arguments and then go to jury instructions. All right, very well. If we'll go ahead and bring jurors in, please. All right, ladies and gentlemen, welcome back. As I mentioned immediately before the break, the state has rested its case, and so we turn to the defense, and I ask, is there evidence for the defense?
No, Your Honor, the defense rests.
All right. So, ladies and gentlemen, this concludes the evidence portion of this trial. There are two still important stages to go through before you begin your deliberations in this matter, and those are the arguments of counsel to you and then my instructions to you on the law. I'm going to need an opportunity to discuss with counsel the instructions that I'll be giving to you on the law. That will take us a bit of time to do. And so what we're going to do is go ahead and recess for your benefit or release you for the remainder of the day at this time. When you return on Monday morning at 9:30, we should be ready for the closing arguments and then my instructions, and I expect at some point during the day on Monday that you'll begin your deliberations of this phase of the trial. All of the rules that I just gave to you before the last break are critically important as you go through the weekend. I remind you again that there is media coverage of this case. You need to be extremely careful around all media outlets, internet. Please don't violate any of the rules I've given you. You must follow them to the letter in this case. With all of that being said, again, we thank you very much for your service. If the weather is any issue on Monday morning, again, Ms. Harrell will be contacting you probably as early as, say, 7:30 in the morning. My arrangement is to talk with her about 7 in the morning, and so she'll contact you as quickly thereafter as possible. So if there is any issue with that, we'll certainly take your safety into account. So thank you very much for your service. If you'll leave your notepads in your chairs. 9:30 on Monday morning. All right, outside the presence of the jury, at the close of all the evidence, are there any further motions to be heard before we move to a charge conference?
Yes, so we knew a motion for dismissal of our charges and a motion for non-suit based on insufficiency of the evidence.
All right. That motion is denied. All right, let's turn then to a charge conference to discuss the jury instructions to be given to the jury as well as the form of the verdict sheet. Yesterday at the end of the day, I gave you a printed copy of the instructions that I would propose to give. Let me read for the record just the pattern numbers that I would propose to give, and then we'll hear about any objections, suggestions, or corrections. So the ones I would propose to give are 101.05, function of the jury, 101.10 is burden of proof and reasonable doubt, 101.15 is credibility of witnesses, 101.20 is weight of the evidence, 101.30 is effect of the defendant's decision not to testify, 104.05 is circumstantial evidence, 104.15 evidence of similar acts or crimes, 104.20 is testimony of interested witnesses, 104.25 is accomplice testimony for the prosecution, 104.30 is informer or undercover agent, in this case informer, 104.50 is photographs and diagrams as illustrative evidence, 104.50A, photographs and videos as substantive evidence, 104.60 is admissions, 104.94 is testimony of expert witness, 105.20 is impeachment or corroboration by a prior statement. Then we move to the substantive offenses, which are 206.11, which is the instruction for first-degree murder where no deadly weapons used, but I've incorporated the definition of a deadly weapon into that instruction. I've also incorporated 202.10, which is acting in concert. And then the concluding instruction is 101.35. And with respect to the first-degree murder, I've included both theories, premeditation and deliberation, as well as felony murder, and I've also included as a lesser included offense, second-degree murder. In going through this, I noted I'd not included 105.35, which is impeachment of a witness other than the defendant by proof of a crime. So that would be added to the list as well.
Okay.
So let me hear first from the state. And you'll also, with respect to the verdict form, the clerk may have one ready. So it has the theories I just discussed, also has the standard instructions regarding the indicating on which theory the first-degree murder would be found if it is in fact found. And then I've also included they answered the first one, yes, that it was based on acting in concert, and they answered the second issue, no, that the defendant did not personally do any of the elements of first-degree murder with premeditation deliberation. Then we would seriously consider giving the Edmonds instruction with respect to both theories of first-degree murder. As I understand the law, if the jury, under North Carolina law, if the jury were to come back with first-degree murder based on premeditation and deliberation, the Edmonds instruction would not be given. That's what the North Carolina Supreme Court has said. I think under this scenario, I think we should discuss whether it would be prudent to give that instruction if the answer to this interrogatory number one is yes, and the interrogatory number two is no, whether it would be prudent to give the Edmonds-Tyson instruction.
And so, as I understand your question, if they answer no, you're not saying that you're declaring it a life case at that point, but we would go into that's why I'm trying to figure out what the purpose of this is. Is it for you later on in crafting your instructions to the jury in the sentencing phase?
Yes.
Okay, and that's what I guess maybe that's what we should start with.
Well,
because there's other theories under which a defendant can be that can get through the Inman inquiry, and that is being a major participant unknown.
Sure.
And that's why I was trying to figure out if you're tying us to the answer on this as to whether we proceed further. And you're saying no, okay.
No.
And that might be what our dilemma has
I'm simply
been.
saying that it will
Help you.
help us decide whether the Edmund-Tyson instruction should be given in the event the jury comes back with a yes, first-degree murder on both theories. I think the law of North Carolina would support not giving an Edmonds-Tyson instruction in that scenario at all, that it would not be necessary because the jury has returned a verdict of guilty of first-degree murder with premeditation and deliberation. But I'm concerned about the acting in concert issue. And that's where I would say that I think I've explained it.
And I understand you now. I think that our panic was that this makes this sentencing phase either null or we move forward. And that was our dilemma.
Yes.
Because we thought you were asking us to prove an additional hurdle that we didn't have to get to. But I understand now your concern is that if I understand, and to make sure we understand, you're saying that if they answer yes, it was acting in concert the first block, and no, he didn't participate, he didn't have the mens rea and those things, that would structure how you're going to instruct them in the sentencing phase.
Yes.
And in that case, I don't think we necessarily, we have always presumed that there will be the Edmonds issue when we get to it at some point. We've always been prepared for that, I guess.
Yes.
And so I understand now your question, and I will stop talking about this issue.
Right. Mr. Brown.
Yeah, so,
So let's start with the general question that I asked them initially. Let's hear any objections, corrections, and if you want to start
Instructions.
with, if you want to start with this is fine. I'm happy to continue this discussion now.
sure,
Do you want me to do the general ones first, because I have a clear list?
okay.
And, Your Honor, I just want to clarify before I...
Certainly fine to talk about it further on Monday. And I'm not wed to the language. This was really my attempt to try to articulate the issue, but there may certainly be a better way of saying it. All right, that'll be fine. Why don't we just plan to talk about it, and I don't want to take up too much of the day on Monday.
If I come up with some thoughts about it and all proposals, you said about emailing it all, could I email both sides, you and both sides, any proposals I had that would just allow for a quicker discussion on Monday morning?
That would be helpful. Any authority or
Yes.
any revised language or suggestions. And then the other thing, just to, and I've planted the seed for, if there is a second phase, about how that ought to be structured. So I would urge you to consider that as well, as to whether it's a trifurcated proceeding or exactly what the defense's position in particular on that would be.
We'll take that into consideration. I don't know what my position is right now.
Right, I understand. So, do you have several copies of this? Or do you want to just look at it? Just one for each table would be fine. Wait. You got her name there, Jen. You got her name.
Okay.
Yeah. We'll get a copy of the verdict sheet to you in a few moments to review. I wanted to talk a little further about the order of the closing argument. I had heard your objection, Mr. Waller. I'll be glad to hear from you further on that if you wish to be.
No, sir. I think that was a photograph that was not evidence and brought to light a new piece of evidence, something that had not been addressed before.
It was ostensibly used to refresh recollection, which I think would be perfectly within bounds of cross-examination. It did reference new material or asking the witness to inquire into the substance of the photograph and relay that to the jurors. I'm inclined to say, without further strong authority to the contrary, that the defense would have the final argument in this case, that does not constitute a waiver. I think that we were closer when there was an email that a witness was being asked to read, but I think that question was withdrawn, so that's not an issue. So I think that I would rule that, I will rule, don't just think that I'll rule, I will rule that the defense will have the final argument in this case. Do you wish to make an opening, or will you simply make the final argument?
I will make an opening, and then Mr. Brown will make a...
No, I'm talking about prior to the state's making an
That's what
argument.
I mean, that I'm not being very clear about. So
Okay.
the answer to that is yes.
Okay,
And that
very
would be my, just for, and then, so we won't use the same time blocks. We won't share time blocks. We'll each have our own time block.
That's okay. So the order of closings will be Ms. D will make a closing argument, then the state will have its opportunity to make closing arguments, and then Mr. Brown will make the final argument. All right, that's fine. All right, and state, have you decided whether both of you?
Yes, ma'am.
Mr. Waller?
Yes, sir.
All right. That'll be fine. All right, let's look again then at the verdict sheet. And I've not included the questions or the special verdict form that you have on page 11, I guess is what it's referred to. Bev, if you'd hand these. I've not included that in this, but this is just the more standard form. And I'll just ask on Monday whether you consent to whatever form of the verdict sheet we come up with. It would be my intention if we add a special verdict or special interrogatories to the verdict form that it would be some instruction at the bottom instructing the jury what to do to go on to answer some questions, and then before they can sit. So that would be how it would fit in.
Looking over the verdict form, it looks good to us. There's one other issue that I wanted to address dealing with closing arguments, and that has to do with the references to MB.
Right.
And I understand, and we did not object to some of the things that were done there because...
I'll cut to the chase. If you want to use his name, you may.
Thank you.
I would ask you to use it as discreetly as possible. I mean, to the extent you can...
All right, yes.
You know.
But I do want to use it some because I do think there's some issues with his name.
Right. One of the significant factors in my ruling to close the courtroom was the fear that he personally had with respect to testifying. My view is that in this record, his identity would be known. It is a not very closely guarded secret. if someone wanted to know his identity, I suppose they could find it in this record. And that having been said, the factors that went into my decision was certainly a degree of security, but it was also to allow, in the interest of justice, allow the jury to make determination of the truth in this case. And so that was a factor with respect to simply his reluctance to testify in an open courtroom. So that having been taken off the table, I think now the balance shifts the other direction, and that the interest of an open courtroom and public engagement in the courts outweighs the interests in closing the courtroom. And I do understand that it is germane to your arguments that his name be used. So I think that at this stage I would simply ask you to use whatever discretion you can to continue to be considerate of his interests, but I think at this stage we just simply move forward. State wish to be heard further. All right. With respect to the to the latent print examiner, I would ask that you respect that request, that she be referred to as a latent print examiner if you do need to refer to her.
That's fine.
Yeah. All right. All right. Well, no, I'm not even sure. I guess it's her. Anyway, I'll leave it at that if that's.
We would ask that continue just to refer to her as a late print examiner. There are broader issues with her.
Right, I understand.
And we have no problem with that at all.
All right. Are there other issues that we need to take up before we, yes?
We have a witness who has been unwilling to sign a release, and there are some important matters related to that, and so we are in a position where we would want to approach you and ask about getting a court order for that.
Would this be an ex parte?
It would.
All right. Do you have something in writing prepared for me now?
No, you do not. You can get it prepared very quickly.
Are you? And when I'll wait till you're finished.
We can get it prepared very quickly. But we have a machine that we can change that.
All right. Yes, Ms. Shakin.
Have you dealt with the issue of the records yet?
I'm sorry.
Okay.
I've not had an opportunity to review this evaluation. You're talking about the educational records?
Yes, and what I would say is I've reviewed Ms. D's ex parte motion, and what she has gives me, I have the report from Dr. Evans. They gave us that a long time ago, but what I've given is fairly not helpful. I mean, there's a lot of information redacted, and my position would be in just reviewing that, if those are witnesses that are called, that there's no way for me to even cross-examine them given the limited information that I have. Specifically, I'll point Your Honor to an example where there was a report card and all the other grades were redacted, just those. And so I would submit in an effort, in a fairness to the state, that we aren't presented. It seems that they're picking and choosing the kind of information that we could get. So I would ask Your Honor to consider allowing us to have the full academic record. And I know you've got some things to review, but that's been my position and what I've given, that I don't feel like it would be helpful for us to have any sort of ability to cross-examine the witnesses.
Your Honor?
Yes.
Just the page that the other teachers are redacted, so it just represents the teachers that are anticipated as witnesses, but there is a sheet in there that has all the grades for that year. So all the grades for all those years are present. It just doesn't have the names of the corresponding teachers for them, but the grades are there.
I guess my concern is I have kindergarten and then 6 years later, and there's nothing in between. What I've been given from the state is some Child Protective Services records in the early 90s, some information around 01, 02, and then 06, 07. And so their whole, I mean, again, I feel like in a broader picture, I don't know exactly what these people are going to say, but there clearly are a lot of records that we don't have. So I tell you that.
And so the state has received this report from Anne Marie Evans, is that correct? Yeah. Ms. D, it does seem that, if a witness is anticipated that's going to testify as to the subject matters that are in this report, there are a number of items in the educational records of Mr. Smith that certainly are germane to this report and would either be consistent with or perhaps impeach the findings of this person. And so it's one thing, I think, if there some school teachers from certain grades who are getting on the stand and saying fairly general things from 4th grade and 8th grade. It's another thing to have someone who says, I was part of a team, these are what we evaluated, this is what we found, this is what we did, and the underlying records that would support or impeach that are in the files that so far have been kept sealed. So,
in complete candor, Your Honor, I haven't. Anne Marie Evans is not a part of my chronology. I haven't looked at her report in years, so that is. I mean, I'm aware of what's in there, but I understand what the court is saying, and from my perspective, it was just not a track I was on when I was reviewing the type of records that were tabbed, and I was trying to identify those specific teachers who would be called and make sure that we had extracted from the records everything that related to those type of records for those people. So that's simply, the question you're raising now is just one that we've not taken the minute to think about.
Well, I haven't asked you to, because the tabs I gave you was my first pass of the record saying, okay, these are not in balancing their privacy interests versus the relevancy. These are the sorts of records that I would say the state ought to have, particularly if you're calling teachers from these time frames. They ought to be able to at least see, what these teachers had to say. And so but then since then I've gotten this report, and I'm aware of what this report is. And it's a psychoeducational evaluation, and many of the records that I, in my initial pass, said, well, the interest in privacy outweighs the interests of the state in receiving them and any purpose they might use them for in the guilt innocence phase. Now, perhaps the balance is shifting, because now we have a witness who's going to be talking about psychoeducational evaluations, and they at least become relevant for the purposes of impeaching and cross-examination. So things have evolved since I last looked at those records, and at a minimum I probably need to go through them again with this report in hand and say, all right, now these categories of records have also become, in my view, relevant.
As a sort of a first step on that, would you like for me to go ahead and hand you all of the records that were sent to you originally?
That would be fine.
And,
Ms. Chiquita, go ahead.
That's my concern, as we're talking about next week potentially, and we've handed over 5,800 pages and discs of things, and each time I stand up before you have to ask for stuff for us to anticipate next week, and it's simply not fair.
Well, Your Honor, we got all the shoe-wear impressions after December, when that turned out to be one of the most significant things they argued. So everyone struggles to get everything done on time.
We'll move as quickly as we can. There's some things that are just by nature, moving targets. So, yes, I'd like to review those. I'll do that over the weekend. Monday morning, I'll be in a position to make what hopefully will be a final ruling on the, thank you, ma'am, on the school records that I have. And then, with respect to this, you have an ex parte motion that you're going to bring to my attention.
Yes, I'm working on that right now.
That's fine. All right, and we'll consider that and then also keep the state's interest in mind as well as we consider whether it should be released. Anything else that we need to take up before we recess? All right. I think I have all of your emails, and so at some point, probably Sunday, I will send you what I deem the final instructions to be. I'll by that point have made a decision regarding this aiding and abetting instruction you've asked for, and I'll also the only thing I think, in my view, that may still be open is the special interrogatory, special verdict questions that I'll just wait to hear from you on. And then any final objections, corrections, or suggestions, I'll invite you to make them Monday morning when we reconvene. All right. Very good. We'll be in recess until 9:30 Monday morning.
Superior Court stands in recess till 9:30 Monday morning. Yeah.